All right, I think we're finally going to move ahead and start. Let's see. Up first, the prosecution. Judge checking his DMs, probably.
Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk,
What the fuck?
the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack.
Wait a minute. Was that a Jungle Book line? Wait, is my memory, is that a Jungle Book line? Or am I tweaking? And why would you open up with some, see, if I'm a lawyer, I'm going to just be very direct and not use all these analogies and all this stuff. Already in the first 10 seconds, I'm scratching my head like, what are you talking about? Can you just say what you really mean here? What? Already. What?
Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all.
Can you guys hear it? Thumbs up.
Exercising your civic duty.
Lion King, one of them.
And honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book.
I knew it.
In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting,
Eva, what's
the
up?
group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members.
She painted the picture.
Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago.
We don't got Bloods or Crips in Chicago. What are you talking about? We got GDs, Vice Lords. Like, they just be saying anything, man. It's crazy. We do not have Bloods and Crips in Chicago, man. What the hell?
But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices.
Linguistic choices.
That committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself
305 shut
under
up.
an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Believeland.
She said it. I didn't know she was gonna say
You
it.
may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area.
All she gotta do now is say Brazy.
Maybe you've
Please.
even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now.
Jeffrey is Young Thug, by the way, y'all.
He was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL.
Imagine.
Because this was a group of people associated in fact.
Yeah, imagine the gangs got secretary, they've got the minutes logged and all that stuff. Of course they don't got documentation. What are you talking about?
Use common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself.
Snitches.
Now, as to how
Snitches.
those members and associates will respond or act once they're actually in court and on the stand,
Oh, what's this?
that's something that I am truthfully not able to predict to you fully.
So what she did right there is bring up that basically they're gonna have snitches testify. People are cooperated, right? Pleaded out and are cooperating. Come out there, and then she just gave the disclaimer here that, you know, once they're on the stand, though, they might not play nice. They could switch up their story, which, you know, could happen, honestly. But so she's giving them a little disclaimer there that you know, that could happen once they bring in those witnesses to the stand. They might switch up their story, not cooperate after all.
But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotics sales. And last but certainly not least, murder. What you will not hear any evidence of
What?
is that the defendants were not involved in a criminal street gang.
What?
You will not hear any evidence that they did not commit crimes on behalf of YSL.
Yo, I don't know that you can really like say that. That's kind of a wild statement to say. If I'm understanding what she's saying here, she's trying to say that you're not going to see anything that's going to disprove that they're, yeah, that's kind of crazy for her to say that. That's crazy for her to say that. That could backfire.
And as I stated to you earlier, what I'm saying to you now, this is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting, and under Parker
I
versus
knew
the
it.
state at 277.
Why don't we take that up and
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
I told you, I knew that didn't sound right. She basically was trying to tell the jury, like, nothing that they can say is gonna basically say that they're not guilty of this. Like, you can't really say that. Goddamn, I'm not even a lawyer, and I know some of this stuff. You know what I mean? That's crazy that came out of her mouth.
yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier? That the burden never shifts to the defendants to prove for certain innocence. They're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
So that's what it was. She burden shifted, and yeah, that's crazy. That alone would probably give the defense, if they were to be convicted, grounds to file an appeal and potentially get that overturned. That's wild, bro. And from my understanding, can anybody double check? Is she the actual DA? Who's the DA in Georgia? I don't know, but I think she's high up on that, high up in there on the prosecution or whatever.
The evidence will show that YSL did not adhere and does not adhere to all of
Watch
the
it be a mistrial?
customs
That's early.
of
It's
a
too early to tell,
traditional
but
street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activity.
Family Tafa Willis, look her up. Is that her? Monica, can you confirm? Is that her?
And again, the head of this gang is seated in this courtroom too.
Oh, Fanny.
The last paragraph of that poem that I read or spoke to you earlier.
That's not her? Can somebody find out who this is?
Because of his age and his cunning, because of his right.
This is argument. This is not
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so sustain the objection, okay?
He's shutting her down. This is a bad opening for the prosecution.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew, and they knew, that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have
Not
his
the sister.
reach out to somebody else and eventually get back to King Slime, as they called him.
It's so funny to hear her say that.
Evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members.
Adrian Love,
You'll hear
prosecutor.
evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed.
Chat, can you guys hear this? Is the levels good on the video?
That YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at
It's good?
war
Okay.
with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come
Perfect.
in here and
Cool.
tell you more about how the Inglewood family bloods in any way made its way down to Fulton County.
What's
You
up,
will
Leo?
also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies. 2015. Gunned down. Openly and notoriously.
Leo said on chat, representing someone with money on serious charges like this, lawyers are getting, oh, they're absolutely getting paid. Absolutely getting paid. Absolutely.
Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do.
Well, Thug's
is
lawyer
to
for sure.
establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years.
Hold up. Somebody in my IG chat, Jack said, her name is Adrian Love. She was the DA for my murder trial in 2011. Dog, you was on a murder trial? What are you doing in my chat? I'm joking, man. Holy shit, that's wild.
At least 3 that are referenced in this indictment.
She made me fall asleep.
You'll find that as a result of this gang's activities,
You know, it is what it is.
a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift young Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state is proving to you over the next several weeks.
Wait, is he on IG Live from the pen?
Conspiracy to violate.
Why'd you say that? Yeah, Serena said, yo, is he live on IG? Is he on IG Live from the pen? I don't think he is. Hey, yo, Jack, can you confirm whether or not you're locked up currently watching live of your former prosecutor? Oh, y'all are wild. I hate y'all.
The Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an...
Hold on, we got a response from Jack on IG Live. He said, nah, shawty, I beat my murder trial. I'm at the house with the wife and kids right now. Hey, man, congratulations, dog. Congratulations right there. Hey, they hit him with the not guilty.
Unspoken, but no less an agreement to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of...
Yo, wait, I'm sorry. Yo, 305 said, oh shit, he loose? Let me not tell these jokes. Hey, yo, leave him alone, man. Hey, you're innocent until proven guilty. All right, clearly the jury found him not guilty. He didn't do it. Y'all are trolls, man. You doing anything on Kick after this? Yeah, we'll be live on Kick. Doing something.
It's sort of like if two people said, okay, you know what, we're going to go toilet paper our dean of admissions house.
You're never getting a follow-up to the Murder Troll comment.
And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm going to arrest you all for conspiracy, for planning to go and do this.
Serena said, congrats to Jack. Congrats,
The
Jack.
evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine, does this action show that they're agreeing to participate in this organization, this enterprise, through racketeering activity. You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses.
Live, what's up, bro?
Whole houses out of which
I appreciate that, man.
drug sales were conducted, where they held long-arm guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Flamarius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
It-
You have an objection?
Yes, sir.
Basis?
For motion.
That's 3 objections.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters at your deliberation.
Oh, that's not good.
And we'll call you back in just a minute, okay, when we finish up our business, all right?
Hey, this is not good that during the opening statement, the judge has to excuse the jury so he can straighten some stuff out. That's 3 total objections the defense made throughout the opening statement of the prosecutor. This is not good. This is not good. They're actually kind of wild. Actually kind of wild.
Admonitions, ladies and gentlemen.
Actually kind of wild that you are giving your opening statement and you can't even get through it without getting called out 3 times. At least one of which for sure was a real L, which is her shifting the blame over. It looks like he's gonna have to resolve whatever he asked, and I missed what he objected under the grounds. We're about to hear it here in a second. Real quick, for anybody that pulls up into the stream, y'all, if people are asking what are we doing, if you guys in chat can let them know, that way I'm trying not to talk too much over the commentary so we can hear what they're saying with their opening statements. And also make sure to come on over to watch right now on kick.com djmoondawglive for the higher quality stream and all of that stuff. And we are going to be killing the IG and the TikTok here shortly. We're going to continue it only on my Kick and my YouTube channel. So yeah. Right now, this is the prosecutor. Yo, chat, remind me of the prosecutor's name right here that's doing the opening statement. She fumbling hard, man.
Our jury has left us.
Let's see what the judge has to say about this.
All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to the honorable court's attention, 1? And 2, how do we just violate court orders? So, yes, I have a serious motion for a mistrial because it's intentional misconduct.
Ooh.
That's my motion.
Oh,
And
my.
I like the...
Oh, yo, he dropped the mistrial grounds. Yo, do y'all understand how crazy this is right now? Mr. Live, welcome back, bro. Good to see you over here. Do you understand how crazy it is right now that Steele, this is Thug's attorney, primary attorney, came out and is accusing the prosecution of withholding evidence or withholding the slides that are used in the presentation because they want to see what they're going to present on so they can build up and know that, which supposed to happen. Oh, oh, this is not good, bro. State is fumbling so hard.
Screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it is next court exhibit in order of the state's presentation anyway, so. All right, so that'll be court one for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because
she's stalling.
that's part of the indictment.
You hear her?
And that's part of the evidence that the state expects will show. Or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Did she just say a whole lot of nothing? Did she literally just say a whole lot of nothing? You saw how she had the long pauses in what she was saying here, thinking about it as she went along to just try and like finesse her way out of this. They said she's lagging for real. Smith, thank you. Salute, bro. What's up? She is lagging hard. Hey, it's like she's buffering. You got the buffering circle on her in her brain. Does it go to whether or not the defense and their witness this is not good, man. This is not good. She's wasting time, all of that. Has nothing to do with the objection. Yeah, he's just all over the place, man.
Represent Mr. Ryan.
Mr. Blaylock, man.
Excuse me. I would never said this ever. That's it.
Okay, what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before the honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this honorable court outside the presence
He's
of
pissed.
everybody. We're an open statement. I am lied to. I am saying that. I am lied to. I don't know if anyone else got that exhibit. I did not get that exhibit. And I'm seeing everyone say shaking no. And now it goes against the court's order. We are bound, duty bound to follow this honorable court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that. I ruled upon that last week.
You just hold the L. Big.
We were not. I would take it as it came in this case, and if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that
She's just spit it out.
rises to the level of mandating a mistrial. Certainly not. It just isn't.
What? Yo, what the fuck kind of woman logic was that shit I just witnessed right there, bro? What was that? Did you hear her at the end? She says, it's just not. Like, what? What? Are you kidding me? In no world would this ever fly. Yo, Jack, welcome to the other side, bro. Hey, y'all, there's Jack, the one who beat his murder case. He's in the Kick Chat. Welcome him to the channel and all of that. Guys, what? Wait, Kathy, don't kill me. All right, I said woman logic. I'm sorry. That was a little extra. Maybe it was just her personal logic. I'm sorry. I take it back. It wasn't woman logic. But she just gave up and was just like, just because it's not. Like, who says that? A 3-year-old? A 3-year-old said something like that. I can't believe she. Let me run that back a little bit. Listen to her just trying to fumble around why this doesn't rise to the level of a mistrial. And then at the end, she's just like, just because it doesn't.
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
you can't make this up. Just
the slide.
Well, now
I have it now. I'm
court
about to
has
share
court
this.
won for purposes of the motion for mistrial.
let me tell y'all something. I'm convinced that a lot of these prosecutors don't go to trial enough because they're so used to cutting deals just to, like, no lawyer wants to lose in court. It doesn't really bode well for them in their careers, right? Especially if they have like political aspirations and all that stuff. Like, you want to win, whether you're going to stay and climb up and you're going to take the law and go up the political route, or if you're going to a lot will start in prosecutor, all of that, and then they'll go into the criminal side and bank that way because they learn the system from the inside, which is a smart thing, right? None of these lawyers want to lose, so I tend to think that a lot of them will avoid going to trial if they could just get somebody convicted off of a deal. Cutting a deal saves me time. I can move on to the next case. You're going to do time. It looks good because it looks good, right? Some of these motherfuckers is just not equipped to go to trial and litigate in a trial because they're so used to just cutting deals and people just giving in and just saying, fine, I'll take the 1 year versus the risk of going to jail for 5. That happens a lot. And a lot of people are not in the position where they have the good lawyers that would tell them, like, oh, we're going to fight this. You're not going to do 5 years. No way. They get a public defender. Public defender might be like, well, yeah, it's a good deal. Like, bro, are you in bed with these guys? Like, what? So a lot of people will just take the deal, go do a year or whatever it is versus the risk of going for longer. And then these prosecutors, again, it's another dub for them. So to see them go in an actual huge trial like this really separates that level of skill, because I'm sure that when we see the defense start talking, I'm willing to bet that that's going to be a clean, very fluid and well put together opening statement. Right now, Ms. Love right here is fumbling, bro. What's past fumbling? Whatever's past fumbling, she's doing it. Like all the errors in what she said, objections on opening statements. Now hold on. Are we good? And then there was the prosecutor withholding slides that the defense was supposed to get, and that the judge already ruled on needed the information that was on the slide shouldn't have been there in the first place. So they have every right to be like, yo, this is a mistrial. Y'all already messing up and we just started. A tackle from a linebacker. After opening statement, she wants to settle faster than Diddy. Oof. That's funny. Here's the line. Let's see what it has on the thing. Oh, Rogerless Ryan. They have his name up there. Yeah. Now, I'm not sure why the defense is adamant about not including this. I think the lawyer said that he represents this guy as well, and his case is still pending. So maybe he doesn't want this to interfere with that trial and that situation, She's drunk. She's not drunk. This is the Young Thug trial.
65. That I see where you have that at the bottom, represented by Brian Steele. So We can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So.
Your Honor, I'm supposed to ask for a reoccurrence report for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
You've made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as court one for the purposes of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacting through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us. So
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right.
Not a good look for the prosecutors, man.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion. But to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation. And just like this, so I assume that what you told our jurors is what you expect the evidence to show? Yes?
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name, on here.
I got that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel?
She don't know.
I
He's
don't
telling
mind
us.
sharing.
Well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was going to happen.
She getting her ass chewed. Here we
I
go.
got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this.
He's chewing them both out.
Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen.
He's chewing their ass out.
So, have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them
What?
Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
Can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, Ingram, can you find out if our jurors are ready?
Let me tell y'all, right, guys, like, you have to understand in the courtroom context, what the judges did right there is ream their assholes. Pause. That was the legal proper way a judge chews the lawyers out. And him saying that you're not by doing this, you're interrupting the jury, you're not making yourselves be the proper advocates. He's like, you have to understand the verbiage, what he's saying. He's basically saying in layman's terms, y'all are make yourself looking fuck stupid and not look like you know what you're doing as lawyers for your clients. Like, you're looking messy. So he chewed out the defense, somebody on the defense, when they came up and they interrupted right at the beginning for whatever they went up to the bench for, and now he's chewing her out. So it's already off to a sloppy start, to be quite honest. I definitely think the prosecutor more so than the defense at this point for getting their ass chewed out. This is pretty wild. This is pretty wild. Hey, real quick, y'all, we're going to kill the TikTok streams. If you're on TikTok, come on over to kick.com/djmoondawglive. Come watch the rest of it over here with us, all right?
Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, Your Honor, Jay Apt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
Max Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell. We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial, and if Your Honor...
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial?
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes, all right?
So there it is. They're taking a small recess. We're going to skip ahead to that, but that was a really messy, man. Super messy on the part of the prosecution here. Not looking too good at this point. Let's skip ahead here, and I think we will have the jury back in here and all of that stuff. Hey, once this part's done, we're going to watch the defense side, and once the prosecution side's done, y'all, we're going to kill the IG stream. So bring y'all asses over to kick.com, djmoondawglive.
All right, have we concluded our sharing exercise? I told you all.
Judge is pissed, yeah.
Go ahead and talk with each other through when we broke.
I did share it, Your Honor. As
All right.
well, if I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hilton shared with me what was said on the bench. But as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, you know, out of including things, but
what?
Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act, and it is what the evidence is going to show happened. What I have in the PowerPoint I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I
She don't know what
said
she's
is that
talking
on the
about.
day that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that, that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are the things that the courts have said jurors and the courts should look to in determining whether something is done in furtherance of a gang. And so I would ask the court, I did take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. Adam. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as...
Say again, madam? I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to...
Yes, ma'am, I would probably agree with you, but did I ever rule on that issue?
You said that you would do it later as it came
Okay,
up.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Oh,
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner. Okay? And give me the full breadth of, so I can rule upon it accordingly.
They got
That's
sassy.
what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks, and my client has nothing to do with that.
y'all, this is getting sassy. Like, as a lawyer, you don't want to piss off the judge. And she definitely got under his skin. He had to clap back right there. This is sassy season in the courtroom. This is crazy.
But I didn't get that
Ms.
slide
Love says
presentation earlier.
Ms. Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay. All right. Now, Mr. App, what is it you want to tell me?
I'm so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your
Love
objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us.
Oh, this is
Even though
bad.
The court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Wow. This is messy.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I sent to them.
Bro, she's capping so hard.
Actually, I sent them to them. So there are some, I have only about.
Your Honor, they're a dump over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Apps.
So all of these slides that involve Christian Eppinger, I sent to them. And other than the slides involving Christian Eppinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle. with the placards of showing the bullet defects, that will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint.
This judge is annoyed. Look at him. He's so annoyed right now.
That has been objected to as being admissible at trial. And I believe that, I'm not certain if Mr. App thinks that we only served 4. Maybe, I don't know if he had trouble opening it up, but we served, I think all of them.
I think all of them.
If not the great majority of them, because I don't.
Or the great
have that
majority.
many. I don't even.
Is she really saying these words? Because it doesn't help her cause here. I think, and the majority, that's not what was required. Bro, she is over here wasting the court's time with a whole lot of word salad that not really is addressing the crux of the issue, which is they did not send over the full slideshow for their opening argument presentations, which the court ordered both sides to do in exchange. This is blatant misconduct, bro. You don't just, oops, I forgot to do this. At a trial at this level, as big as it is and televised, bro, this is a massive, like they are trying to purposely screw over the defense. It's just blatant. There's no mistrial yet, but I swear to God, this makes the argument more and more valid. Even if this trial goes through on appeal, let's say they get convicted, they're going to be running this all day just off the opening statements from this stuff right here. Because this is bad. This is bad. You can't be at this level of in your career as a prosecutor fumbling this hard. It's not even a fumble. Let's be honest. It's purposely done. This is intentional. And her trying to get herself out of it right now, she's saying a whole lot of nothing. Just listen closely. She's saying a whole lot of nothing.
We have 20 photographs in this PowerPoint. So everything, and I can show the court, I would share it if I did not, with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted, and then I have pictures of Christian Eppinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument. But if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's, no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of our opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and you know, Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today.
The best part of these trials is the lawyers battling.
Or whether their text is part of her opening.
All right, Mr. Matthews.
Yes, Your Honor. Good morning to the Honorable Court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from a text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. That's number one. Number two,
Wrong information.
the quote
That's sloppy.
in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquavius Huey. And then when you go to slide 16.
This is embarrassing, y'all. This is really embarrassing.
Slide 16.
She had her clerk write this opening statement or something?
That is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020. But in the indictment, that particular Overt Act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury, Judge. So I would ask that the state correct that, remove it, or correct it.
All right.
This is embarrassing, bro.
Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet, and I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else?
This is all the lawyers are getting up, man.
Yes, Mr. Steele.
Thank you, sir. If you would look at also number, I'm looking at now, 48, 49, 53, 54, and 55. That's your prerogative. That's within your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides you talking about, Mr. Steele, again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so 48, 49, but then skipping to 53, 54, and 55.
48 and 49.
This is a messy opening, man. Super messy.
The slides that Mr. Steele.
I would, yes.
They said she's catching a full beat down by each lawyer. Hey, look, I'm gonna pause it. The reality is, it's two of them prosecuting, and there's at least 5 defense attorneys that I can tell that have stand up so far and spoken. This is like, again, this is like being in a COD match, and all your team is down. It's just you and your one other person, and you got a full team on the other side. You're trying to 2v7 them. Like, it doesn't usually end up well. And it's just the reality of a RICO trial. But this goes to show you that already it doesn't, to me, off my first impression of the attorney Love here, I think it's her name, right? Love. that she's equipped to handle this big of a trial. A RICO trial typically looks just like this because you're charging all of these people at once. They're all going to have their individual lawyers, and you're battling each one of them. Like, it's a lot of work. So to open up and fumble this hard is definitely not going to sit well. Judge is irritated. Now the lawyers have gone through the slideshow and have pointed out so many other errors, grammatical errors, incorrect information, as well as just blatantly wrong information. It just makes everything look like this was completely ill-intentioned by the prosecution, or at the very best was sloppy lawyer work. She must have had her paralegal write the entire opening fucking up and just showed up to read it back and regurgitate it, and without proofreading any of it herself. It's just bad. Just a bad look for her.
And you said Mr. Simmons at 45?
Just share the presentation, please.
They said, did the state get this research from their case on Wikipedia? Probably did. This 100% could have been stuff they did prior to the trial starting. This is just, it totally just disrupts the flow and prolongs the trial.
Okay,
you know.
So, Your Honor, I'm showing on the screen slide 48, which is the last thing that the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
A level of incompetency, yeah. It's either incompetency or just willful, intentional,
It's not 50, sir, 53.
you know, bad lawyering, you know, trying to withhold stuff to screw over the defense.
And 53.
Neither one of them is good.
What I expect the evidence is going to show. So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way
Or she has some other agendas. Of course, she wants to win.
a lane that is not
What's up, Pickle?
belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are embarrassed. So I can take out.
So that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor. I went over to the state's table. Carson Matthews, Mr. Bureau, went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, State?
Not yet, but in a moment.
All right. Here's what I'm going to do.
Scratch her.
This is exactly why I told you. I wanted you to.
He's pissed.
Let me go ahead and just say this, Ms. Love. I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So,
Scrap her
this
shit.
is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
Oof.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions.
Oof.
This is why I told everyone. They need to get, and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So
He ain't happy, y'all.
As far as any typographical errors.
I'm not worried about that. I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Shaw have made are errors, and Ms. D. Williams need to be corrected. Okay?
Yes, Your Honor, I will, of course, do it for the record.
And but everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. And Your Honor, I also wanted to point out to the court that
He's over it.
If I spoke, even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point. I'm gonna tell them that. But and I told them that already. But that's not the point.
You should be on top of your shit.
We can have a smooth and orderly presentation of evidence. Okay? So, all right. Desmond, Sergeant Ingram, can we go ahead and call for our jurors, please?
Your Honor, while I walk out, also number 6-2.
You can go ahead and take up that during the recess. Okay?
Yes, sir. Thank you.
All right.
Yo, he's so annoyed right now, y'all. He's so annoyed. And the audacity for the prosecution, Love, right here, to be like, well, you know, just a reminder that Your Honor can instruct the jurors to remind them that anything I say isn't da-da-da-da. That's a cop-out. And he was polite enough to not call her out on that bullshit, because essentially what it is she's just trying to cop out to say, if I just make sloppy errors, don't worry, Judge, you can clean up the mess by instructing the jurors to, you know, not pay attention to that. Like, no, as a professional, you should be mitigating as many errors as possible in a trial. Like, that's wild that she had the audacity to say that to the judge. That's why he kind of brushed her off. Was like, I'm gonna do that anyway, but like, you shouldn't even be, you really shouldn't even be saying this. You should be striving to be on top of your shit. She's just messy, bro. She messy.